Hi, I'm Metta Spencer, and today I have an extremely fascinating issue that I want to explore. Tell me whether you think that if a leader of a country initiates a war without any provocation, without any rationale, just starts a war with another country, should we catch him and throw him in jail? The person who's responsible.
Yes.
Well, okay, folks, we get a guy here we're going to talk to who has strong opinions about that, and he has every reason to do so because we've been working on the issue as a lawyer for a long time. And this is Noah Weisbord. Right now, he is a professor of law at Queen's University in Kingston, Ontario. Hi, Noah.
Hi, Metta. Thank you very much for having me on the show.
Yeah, it's going to be fun. Not only fun, but really important. This book is wonderful. It's really important. And of course, the title is The Crime of Aggression. And obviously, that is important because if we actually made it illegal for somebody to be aggressive, and if we knew what aggression was, and that's not so easy always, then we'd have a leg up on the whole solution, right? Okay, so let's start at the beginning, Noah. Tell me, I understand you got interested while you were a law student and a social work student. Were you doing degrees at the same time in these different areas? And that you got interested in studying violence and aggression and the law regarding aggression.
Yes, Metta. I first got interested in this subject in a social work class on therapy with involuntary patients, so patients that are court-ordered to be in there. And this includes people that were involved in drug use or adult-child sex offenses as part of their sentence or coming in for therapy. And I had a very empathic, wise professor named Ingrid Thompson, who told me about a social experiment going on in Rwanda, which was going to undertake the largest attempt at societal healing, involuntary psychotherapy that had ever occurred, where the entire country would be made to participate in these restorative justice trials called gacaca, where people that were imprisoned for the Rwandan genocide, awaiting trial, innocent until proven guilty, would be brought in front of their communities and judged by 19 lay judges who would decide whether they would be reintegrated into the community or not. So I went around on a motorcycle with my buddy, my friend and fixer, Samuel, who would translate the Kinyarwanda into English for me.
You drove around Rwanda on a motorcycle.
Yeah, exactly. And then we'd interview the people after the trials about how they...
Wait a minute, you were a graduate student at the time, but this was going to be like your thesis or something?
Mm-hmm. It was a joint law and social work thesis. And the theme of it was the relationship between justice and healing in the gacaca trials. The name of these trials, post-genocide Rwanda participative trials. So this was an interesting subject to the prosecutor of the International Criminal Court because he was prosecuting members of the Lord's Resistance Army, this bizarre cult-like army in the northern part of the country, and some of them had escaped the bush and had attempted to go back to their communities, and the communities were using a restorative justice process called Metta Oput to reintegrate them. And the question the prosecutor was interested in at the International Criminal Court, when I became his law clerk, was whether the International Criminal Court could prosecute somebody who had already been through this process, or whether the fact that they had already gone through a restorative justice process precluded International Criminal Court jurisdiction. So this is kind of how I got into it.
My mind has boggled back there, and I'm still thinking about, Lord's Resistance Army. Whatever happened to that guy? And until we settle that, I'm only half listening to you. What did ever happen to the guy? Have they caught him?
Of the 5 indicted Lord's Resistance Army leaders, a number of them have been captured or killed, but Joseph Kony himself is still at large. So we don't know what's happened to him. There was a massive manhunt involving US troops and Ugandan troops. And basically, when the International Criminal Court shone its kind of spotlight on the situation, it changed the political situation on the ground, and it allowed more effective military response to try to capture or kill these leaders. And the Lord's Resistance Army was broken apart and lost much of its functionality. So it's no longer the threat it once was.
Really doing much damage, or maybe it doesn't exist anymore, but the guy has never been caught himself, this Joseph Kony.
Right, yeah.
Thank you. Now I'm I can go back.
We can move on. Yeah. So you had asked me about how I got into this stuff. It was through social work and law. That these trials in Rwanda were meant to bring justice and healing to the whole country, whatever these concepts mean in the wake of such devastating violence. And I was interested in how justice and healing relate, and whether they're compatible or whether they run up against each other. Mm-hmm. And that ended me at the International Criminal Court.
Well, now wait, let's anticipate a bit, because what's your answer? Because that in itself is I've thought about this and talked to people a lot about sort of the choice between whether to have truth and reconciliation approach, which aims for forgiveness and reintegrating the person into society, or a criminal court kind of approach like the ICC, which is basically justice oriented. You did some bad things, so you go to jail, and it's an either or kind of thing the way it's normally construed. You seem to hint at the idea that you can do both. Give me your answer in 30 words or less before we move on.
Rwanda attempted to do both, but the blending of justice and healing was a challenge to the process.
Well, isn't that true in real life too? If somebody has wronged you, and do you even want to forgive them until you're sure that they have changed and that they're really sorry? And can you forgive them? I mean, the whole notion of letting bygones be bygones without having assigned culpability and acknowledged blame, that kind of thing. I think interpersonally, just in my own life, that has come up sometimes as a real problem. I've had relationships where I didn't know what morally I should be doing,
One of the main dilemmas at these trials was whether the communities could be forced to forgive if the perpetrator went through the motions of showing remorse, admitting to everything he or she had done, asking for forgiveness in the proper way. And there was criteria of forgiveness that were built into the Gacaca law, which, including a sincere demonstration of remorse, that I thought violated the very idea of sincerity. How can you have criteria of sincerity that if you meet them, then it's considered to be sincere? And then if somebody's forced to forgive, there's a risk that it will continue the cycles of violence. It's another victimization. Mm-hmm. And when it comes to whether justice and healing can go hand in hand, at times they did in the process. When women leaders in some of these communities had enough of the cycles of violence, Hutu and Tutsi, and they tried to make the process a community building endeavor. They tried to get the truth out. They were all dedicated to the truth and to resolving these things and having the community be functional and not full of antagonism. And it would work in these communities. And in other ones, the whole community would attempt to bury the truth together, and there'd be very few survivors to call them on it. There, and a woman who had been sexually abused at a roadblock um, says what had happened to her, and the whole community laughs at her and ridicules her because she's behaving bizarrely, because she's traumatized. It's another victimization. So there was all of these situations that I saw there.
But we see some version of that dilemma in the comparison that's often made between the Japanese reaction to their misdeeds in World War II, or even, for example, the rape of Nanking, and the way the Germans supposedly acknowledged guilt as a whole society. And I have friends who are, Joy Kogawa is a dear friend who's very preoccupied with the what she sees as the failure of the Japanese society to acknowledge things that they should acknowledge, that it really, you can't go on past it unless you actually deal with it. I didn't mean to start our conversation getting stuck here, but let's play with this a bit because I think it's so crucial.
I'm happy to. And it leads into the discussion about whether retribution through a criminal process is the right way to deal with war. So it sets a good groundwork for where we're going.
Mm-hmm. So you say that sometimes it works and sometimes it doesn't. Do you have any clues about what has to, how to know whether a particular angle that one is taking is the optimum one or is going to lead to denial or unnecessary persecution and prolongation of turning a perpetrator into a victim by just dwelling on things after he's already made amends, mm-hmm. that kind of thing. Is there any, do you have any tips for a prosecutor or any human being faced with a personal decision about how to handle someone who's wronged him or her?
Mm-hmm. Okay, you're asking a few questions, and the first one is relates to kind of one of my favorite books and thinkers, and the book is Between Vengeance and Forgiveness, Facing History After Genocide and Mass Violence. It's a book by Martha Minow, and what she says in the book is that there's a variety of legal ways to contend with mass violence. And you can have memorials, you can have truth commissions, you can have trials. But what's important is to hit the right spot between vengeance on the one side and forgiveness on the other. A spot where there's not too much memory and not too much forgetting. Because too much memory or too much forgetting can both continue the cycles of violence. Too much memory means that a community is faced with everything that it's done in the past, and it creates, re-antagonizes those old divisions. And this was what was happening on the grass in Rwanda when I would go and watch these Gacaca trials with the community sitting on the grass. There was a risk that the genocidal thoughts and dynamics would start up again when the truth was revealed. Truth isn't always healing. Too much truth can start up the violence again. And too much forgetting is a recipe for continuing the cycles of violence, because there is no justice and no contending with what happened in the past. So there's a sweet spot between those two, and you really saw it playing out in each of these little communities.
Yes, now when you started, you mentioned that this was a case of, or you were dealing with the possibility of involuntary psychotherapy. Mm. A term that, is itself a contradiction in terms.
Right.
And a therapist, I suppose, has to make the same kinds of judgments about when to say, well, let's move on, or no, let's stay with this and look at, mm-hmm. and remember it some more.
Mm-hmm. I think you would have probably made a good psychotherapist as an alternative career path. The trick for involuntary psychotherapy is that it might start off involuntary, but through rapport, the psychotherapist makes it voluntary. So you can't make any therapeutic progress if the person is completely resistant to the entire enterprise. But if the person's being forced in by the state to go there, and they're stuck there anyway, and their life isn't what they want it to be, and it's not usually because they're in prison, then there are incentives in order to try to make changes, and those can be helpful therapeutically.
Mm-hmm. So it isn't necessarily that you have a tip of what situation is one that is indicates one approach rather than the other, but you have the skill of the judge or the therapist in this case of knowing when it's suitable and when you've had enough. Is that what Martha Minow would have said? That it's a matter of intuition or empathic capacity to know when to do what?
I'm not sure what she would say about that. But what I do know that she said was that certain societies will respond better to different ways of dealing with their histories. And in some circumstances, a retributive criminal law approach is going to be better because it will respond to the wrongdoer's false message that the victim is somehow less worthy. So there is some sort of moral balancing that can occur when a court says definitively, what you've done to this person in degrading them was wrong, and that your message that this person, it doesn't have human dignity, needs a rejoinder, and we're supplying that rejoinder. On the other hand, some places, like in South Africa, Truth and Reconciliation Commission was necessary as a political compromise because trials wouldn't have allowed a peaceful transition out of apartheid. And there needed to be something that was a little bit more retributive than just forgiving all of these people for the nasty acts that they had done, the people that had been in the apartheid regime. So there's a variety of tools, and each has their strengths and their weaknesses.
Well, is there a situation in which you can say, this person still feels no remorse? This person has no sense of guilt over having done it. And certainly he or she did something awful, but we're going to forgive him anyway and go on. Is there ever a time when that's the right decision?
Right. Well, this is, Martha has a brand new book that came out in September called When Should Law Forgive? And it addresses that question, exactly that question head on, is when, and what is unforgivable? This is one of the questions that she touches on in the book, because sometimes things are unforgivable and that you just shouldn't be forgiven. If somebody commits a genocide deliberately out of hatred in full knowledge of what they've done, maybe it's not the right situation to be giving them psychotherapy, you know? So this is a deep question. And I think that it brings us into the crime of aggression, and it brings us into the question. In one of the chapters of my book, I go in a little bit into a discussion of Hermann Goering, who was, according to the Nuremberg Tribunal that tried the Nazis for the crime against peace, which is now called the crime of aggression after World War II. Goering was the leading war aggressor, they said. His guilt is unparalleled in its enormity. And the question is whether he was a product of his times, Hermann Goering, and of his situation, or whether he had just decided to do something evil. And the tribunal basically debunked his alibis. He claimed that he was trying to moderate Hitler's excesses, Goering, in his defense. He said he didn't know about horrible crimes that were occurring. And the legal process revealed that he was lying and that he had known about the invasion of Yugoslavia before it occurred, that he had been an enthusiastic participant in some of these anti-Jewish actions. The legal process can sometimes debunk people's alibis and their pleas for forgiveness where they're not deserving of them.
Night before last was an anniversary of the big massacre of the Tree of Life Synagogue in someplace in the
Pittsburgh?
US. Pittsburgh, yes. Yeah. And I think it was PBS had a series of interviews with, I want to say parishioners, but that's a Christian term, members of the congregation. And some of them were talking about having forgiven the mass murderer. And I didn't, they didn't talk about how they did that or why they did that or why they thought was a good thing to do. They just were assuming that forgiveness was appropriate. And I kept thinking, I don't know. I think putting the man away for sure is a very good idea. But what good will come maybe to you for forgiving? Maybe you live a calmer inner life if you are able to forgive someone who has done something terrible to your own family. But I don't know what else comes of it that's good. Right.
Well, this was a tricky question in Rwanda because it was supposed to be a restorative process that would heal the communities. It would bring the Hutu and the Tutsi closer together. It would heal families in the hills of Rwanda, in the villages where interpersonal stuff had happened there, and it would heal people inside. They would feel that the truth had come out, and there was 3 levels of healing that were contemplated. But it's really unclear, how these experiences of watching the perpetrators present alibis or admit to their crimes, how that's going to affect societal healing, intercommunal healing, intracommunal healing, and interpersonal healing. It's very hard to tell. And one thing I know for sure is that forgiveness cannot be forced upon somebody, that it's not going to achieve its healing effect or its justice effect if someone is forced to forgive because the law requires it if certain criteria are met. And you're right. I think the main function of forgiveness, intrapersonally within yourself, is to feel better, to feel freer, not carry this anger and this destructive energy within you. And outside, it's so that the community can go on and evolve. It's a fixation. It needs to be addressed, or some people are not going to be able to live peacefully.
I guess if I try to find a framework in which it makes any kind of sense to forgive someone who is clearly culpable, clearly guilty of in any objective way of doing something terrible, it would be certain religious maxims. I think Christ said, "Forgive them, Father, for they know not what they do." Mm-hmm. And then I don't even remember who he's talking about at the time, but it doesn't matter because the argument is he's so screwed up, you can't really hold it against him because he doesn't know any better. Or his mind is too warped, or he can't be held accountable because he doesn't understand what he's done wrong. I should use less sexist words than his, because I presume there are bad women in the world too. And then I think that is kind of the same as a Buddhist notion of causality. That there's nobody who means to be bad. There are people who have very screwy notions of what is bad, and there's a history behind how they got that belief system. And I think that is kind of the cognitive framework that you hold when saying, this is a sick person. This is not a bad, badness is bad, but it's a reflection of disease or something else.
Yes. There are political repercussions of these frameworks. In Rwanda, the Tutsi survivors, many of them didn't want a restorative process. They thought it was cheap justice. They wanted full-on retribution for the people that had killed their families. And to foist on them this idea of healing was an offensive thing to do for some of these people. So and this is seen in a lot of places where there'd been mass violence, is that the victims of the violence, the survivors, want to have retribution. They don't want healing, and they're being asked then to be empathic towards their, the people that have victimized them, and that's not right, really. So there are limits to forgiveness, I think. In this Buddhist or Christian perspectives that you're talking about are, when they're taken without the context, they're potentially dangerous. It's not always a great idea to forgive Hitler or Mussolini. It's too simple to just think that full empathy is always the solution, in my view.
So let's pick up the narrative where I interrupted you.
No, that's great. It was a great little journey we took there. So Ben Ferencz spent his entire life trying to replicate the Nuremberg Tribunal and create a court with worldwide jurisdiction that was able to prosecute leaders, individuals, for genocide, crimes against humanity, war crimes, and aggression. So this is his whole life project. And in the Cold War, he was often seen to be an idealist, not as relevant as Henry Kissinger, for example. There was only a few years difference in age from Ben, and lived very parallel life to Ben. They had both moved to New York, fleeing anti-Semitism. They'd both gone to Harvard, Kissinger in political science and Ferencz in law. They'd both been involved in the US Army, but Kissinger came out as the arch realist, saying basically that the strong do what they will and the weak accept what they must, until a balance of power kicks in to prevent the strong from being able to proceed. And Ferencz said, no, we need law to hold individuals accountable, as was done after Nuremberg, at Nuremberg. That's what's going to prevent World War III, said Ben Ferencz. And during the Cold War, the Russians and the Americans couldn't agree on a definition of aggression or the creation of an international criminal court. And this was really the most frustrating time of Ben's life, trying to push for these ideas in the midst of the Cold War deadlock. But with the end of the Cold War, in the 1990s, liberalism had defeated fascism in World War II and communism at the end of the Cold War, and was the primary surviving ideology of that long war. Maybe it could be considered a single war that began with the beginning of World War I and ended in 1990 with the collapse of the Berlin Wall. Maybe it wasn't a bunch of discrete wars. And that was over at 1990, and then all of this Nuremberg stuff came back in the 1990s. That was Ben's moment. That's when the International Criminal Court was created, the Yugoslav Tribunal, the
Wait, back up. Hold on. Let me get this the time frame here. He was the prosecutor of the war crimes tribunals or if you call them tribunals, at Nuremberg and all that at the end of World War II.
He was the prosecutor of the successor of one of the successor trials. So there were two
right after the war. It was later.
It was right. There was two sets of trials of the Germans. The first ones were prosecuted by Robert Jackson, the Supreme Court judge, and others, a British prosecutor, a French prosecutor. Then a second set of trials called the successor trials, led by Telford Taylor, took place, where the doctors, the lawyers, the high command, these kind of secondary Nazis were prosecuted. Ferencz prosecuted the Einsatzgruppen, the mobile death squad leaders who had killed over 1 million Jews in occupied Germany. He was 27 years old. It was his first case.
And what year would that have been?
46, I'm guessing. I think it was 1946.
Right, so it was shortly after the war. It wasn't
right after the war.
Now
yeah.
You're talking about something in 1990.
So
a big gap of time there.
So what I was saying was that during the Cold War, Ferencz had tried to get diplomats to replicate the Nuremberg trials at the international level, so that a international criminal court with worldwide jurisdiction, not just jurisdiction over Germans or Japanese, would exist, so that Americans and French and Russian leaders could be tried for these same crimes. But the superpowers who had committed to this idea at Nuremberg were reticent. When it came down to the Cold War, they became more interested in fighting each other than they were in creating a legal system that would hold their own leaders accountable. So Ferenc managed to, with diplomats, usher in a 1974 definition of aggression that basically tessellated American and Soviet positions into the same draft. So it's completely ambiguous. I call it Escher-esque in the book, like the prints of the Dutch artist M.C. Escher that looked like...
Oh, Escher, yes.
Yeah. So, you have white armies walking from left to right on one, if you look at it one way, then turn away from the print and you look back again, and it's dark armies walking in the other direction.
Right.
This is what happened in 1974 international law when it came to defining aggression. American and Soviet positions both built in. And that really basically wasn't used, that definition, for the course of the Cold War. No international criminal court was created until the end of the Cold War, when there was a Nuremberg Renaissance with the communism collapsed. Mm-hmm. Liberalism could inject its own concept of world order into the international level. And that's when you got Nuremberg's idea of individuals being held accountable, individual leaders for these political crimes kicked in.
Okay, now let me get my timing. We have the International Criminal Court, that is the Rome Treaty.
Correct.
What year was that again?
1998.
90 what?
1998.
98, yes, okay. I thought it was about 20 years ago. But they have crimes of aggression, crimes of genocide, all kinds of other crimes, but they don't have the crime of aggression.
Well, they do have it. They have it included, but absent a definition. So there's 4 crimes that get listed in the Rome Treaty in 1998. Genocide, just like you said, crimes against humanity, war crimes, and aggression is added without a definition. Why is that? Because aggression at the conference almost collapsed the entire negotiations. Some states wouldn't agree to including the crime against peace, as it was called at Nuremberg, so they wouldn't agree to the treaty without it in there. This is a number of European states, all of the Arab states. Other states wouldn't agree to the treaty with aggression in there. That means, the United States Security Council members. So there was deadlock. So the solution was, we're going to include it without the detailed
Okay, element. That sounds like a good finessing of the situation, but I don't understand the arguments or the what kinds of debates were there about what the definition should be. I mean, I can think of lots of reasons for saying that it's really hard to know when aggression takes place, because usually somebody has baited somebody else with a, which you can say was a provocation, which is therefore aggression wasn't really aggression, it was just taking care of yourself, etc. That kind of logic of who really started it, oftentimes you really don't know, or
well, this was one of the key debates during the Cold War. So the key debate, the Russians thought that first strike should be the clear indication of who was the aggressor. Whoever struck first, doesn't matter about the provocations. The Americans preferred what they called the principle of intent. So the Russians had the principle of priority. First strike is the aggressor. Americans had the principle of intent. But what mattered was why you struck, whether you struck for to protect human beings from an atrocity or something like this. And then ultimately what happened in 1974 when there was this deadlock was that both ideas were built into the definition. So it was unclear. That's the Escher-esque kind of aspect that I'm speaking about. But when aggression, after the end of the Cold War, we're back in the 1990s, 1998, aggression doesn't get included. Aggression finally gets defined clearly. The best, most clearest description of what it is in history in 2010 in Kampala. So this is the International Criminal Court's Review Conference, and it gets added as a prosecutable crime alongside genocide, crimes against humanity, and war crimes to the Rome Treaty. And what it is it's the planning, preparation, initiation, or execution. Those are the acts, the actus reus of the crime, as they say in criminal law, of a manifest violation of the UN Charter. And what does a manifest violation mean? It means a list of acts taken from that 1974 definition: bombardment, blockade, attacking the armed forces of another state, sending armed bands to attack another state, and a number of other prohibited acts of aggression. So what you end up with in 2010 is actually quite a clear definition that includes conduct of the leaders, the state act, which is bombardment, blockade, a collective act that the leader is going to be held accountable for, and these various ways to connect the leader to this larger act that requires many people to carry out. That was part of the tricky thing in the definition of the crime of aggression. Answering Hannah Arendt's question, how do you hold a cog in the machine like Eichmann accountable for the entire Holocaust? Well, the law has its ways of doing it, and they were built into the definition of aggression. So parts of the Nuremberg Treaty were combined with parts of the United Nations Charter, and like a Lego structure, all these precedents were combined into a consensus definition where all the states agreed at the conference in Kampala in 2010 that this was now the definition of aggression.
Wow. Okay. Now that is fabulous news. And in fact, I knew something had happened, but you've just given me a much fuller notion. But how many, as I understand it, how many countries belong to the ICC?
123.
Okay. And the U.S. does not.
No U.S.
And what other major countries do not?
Russia, Israel, North Korea, Iran. A lot of the countries that are the most militarized aren't parties to the treaty, but their leaders can still be tried at the International Criminal Court.
Uh-huh. Uh-huh. Yeah, beautiful. I love that.
If they commit a crime on the state party's territory. So if a Russian or an American commits a crime in Canada, Canada is a signatory to the ICC treaty, then that leader, the US leader or the Russian leader, if captured, can be sent to The Hague for trial. Mm-hmm. Or they can be tried in any other court that has those crimes involved, that has jurisdiction. So it's not like the International Criminal Court is the only part of the system. It's just one node in a justice system that can try these leaders.
So, but he doesn't have to do anything bad. Let's say a real monster comes to Canada. We are obliged to arrest him if he's been indicted. Is that right?
That's right.
Is the word indictment actually applicable here?
If there's an arrest warrant, if the International Criminal Court has issued an arrest warrant, like they did for Omar al-Bashir, the president of Sudan, and then he traveled to many states that were parties to the court that didn't arrest him. But then South Africa tried to arrest him. And so you have the police that were trying to arrest him in South Africa, and the South African government was trying to spirit Omar al-Bashir out of the country so that he wouldn't be arrested. So even within a state, you can have conflicts about whether the person should be.
I didn't hear that story. When he's at large now, right? Or he's back in his own country?
Well, he's just been deposed and captured, and he's being held by the new government of Sudan. Omar al-Bashir is being tried domestically for all sorts of crimes now. Or he will be tried domestically for a bunch of crimes. And this just happened recently.
According to the ICC, if a country accuses and punishes and tries their own bad guys, then nobody else has to be involved.
In fact, yeah, absolutely. In fact, the ICC is a court of last resort. So it's only able to prosecute one of these leaders if some other country or regional organization isn't already trying that leader. It's a court of last resort, the ICC. The hope is that it's going to incentivize domestic jurisdictions to try these leaders for the international crimes.
Mm-hmm. You were doing a degree in the connection somehow between social work and law, and that brought you to Rwanda, where you watched these gacaca.
Yeah, that's right. It
Trial.
means grass in Kinyarwanda. It signifies justice on the grass.
By the way, before we move on, what's your general feeling about, was that a successful process in general, or do you feel it didn't really do what it should have done?
It started off well, but there was a lack of fair trial checks and balances because the trials had to be sped up and made easier for the lay judges to run. And this is when the government started to try to influence the process. Mm-hmm. I would say that it was very promising. There were some very good moments, but it wasn't sufficiently inoculated against executive interference.
Would it have been sort of like Truth and Reconciliation commissions, or whatever they're called, or would it have been more like Restorative Justice? And I don't even know what the comparison should be.
Well, you're exactly right. It looks like half Restorative Justice, half Healing Circle, half Nuremberg trial, and it doesn't all add up to 100. It's like it's all of these things that were blended. And my question was, were they compatible, and how would they end up working together? All of these different aspirations and values.
And you thought that they might have if the government had kept hands off. Is that right?
I'm not sure. I mean, I thought that in some communities, healing and justice were working well together. When the community would reveal the truth, a perpetrator would admit to what they had done, incriminate other people, apologize, and then be reintegrated into the community because they were showing real remorse. And then you'd see both justice and healing working together. In other communities, the truth just was risking inflaming the passions again and instigating the genocide.
Well, I guess that mixed appraisal would be the evaluation one would have to assign to almost any system of justice. It's not just that one.
True. I hadn't thought of that.
Sometimes it works, and sometimes justice ain't done.
Yeah, absolutely right. Yeah.
Okay. So you went from there to where? This was your PhD thesis or something? And
this was when I was a law student. I traveled to Rwanda and studied this. It was professor, Martha Minow, a professor at Harvard, took an interest in my thesis because she had just written this book, Between Vengeance and Forgiveness, Facing History After Genocide and Mass Violence. And each chapter dealt with a different kind of response to mass violence. And gacaca kind of fit in there. It was kind of an interesting example of it. And she kind of supported my admission to Harvard. So I did my master's in this under Martha Minow. And I wrote a kind of an interesting thesis, which is still in the Harvard Library, which is kind of like a book, which I'm still quite proud of, about the gacaca trials and justice and healing. And then after that, I went to the International Criminal Court as the law clerk to Luis Moreno Ocampo, the chief prosecutor. And that's where, when I was
in... appointment.
Yeah, it was good stuff.
How did you get that kind of first job?
Well, that's where Ocampo was dealing with this problem in Uganda that I was referring to earlier, where in Uganda you had the restorative, process, Metta Oput, and he wanted to see how to coordinate his prosecutions with a restorative process in Africa. And I ended up doing a lot of other things for him, including mostly helping with the speeches and newspaper articles. I went around, helped him with legal memos, things like that. But that's where I met Ben Ferencz and got into the aggression stuff. That's where, I hear the yelling going on outside my office. It's Ferencz yelling at Ocampo. I emerge from my office. Ocampo beckons me over. And then Ferenc says, you're going to study the peace versus justice dilemma for your doctorate, the question about whether to prosecute perpetrators or negotiate with them to try to achieve peace. Well, why don't you put that aside? Why don't you study the crime of aggression instead? Because Ferenc is trying to get the crime of aggression implemented in international law at this point. It's 2004, I think, and it's not defined in the Rome Treaty. It's included without a definition, and Ferenc's whole objective is to get it included. So I'm like, well, what does that have to do with peace versus justice? He said, well, imagine prosecuting the Germans after World War II when we needed them to fight the Cold War against the Russians, Ferenc says. It's the ultimate peace versus justice dilemma. So I thought about it, and I brought the idea back to Martha, and we sat down and we thought, yes, it's probably never going to happen. There'll never be a criminalized crime against peace again, but it sure is a fascinating legal idea. It's the holy grail of international law, in a sense. The Nuremberg Tribunal called it the supreme international crime because it contained within itself the evil of the whole war. Yeah, let's do this. And then I got involved in the working group defining the crime, and that's how I got into this subject.
Okay. And there was already a working group on how to define the crime of aggression.
Yeah.
Okay. And that existed where? And what kind of outfit was that?
It was the Assembly of States Parties to the International Criminal Court. So the legislative body of the International Criminal Court had set up a working group to define it before the first review conference of the court. So there were 7 years that would pass before the review conference would take place, and this working group was going to have a cooked up definition before that meeting. And that was the working group that Ben Ferenc was participating in as an expert, and that's the working group that he got me involved in, that I also participated in, first as a note taker, and then over time I was included as an expert drafting the language and those kinds of things.
Mm-hmm. Okay. As of now, have most people agreed with that definition? Most people, most states, officially, has it caused any problem within the states parties to the ICC? Are there people, countries that find it difficult to accept that now?
In 2010, all those questions were put to rest because states were asked to vote on the definition at the end of a 2-week conference, this review conference in Kampala that I spoke of, and they agreed by consensus on the definition. It was actually basically the definition that states had worked on, mostly in Princeton, New Jersey. That's the one that I've been so involved in with Ben. It was the working group headed up by the Liechtenstein master diplomat, Christian Venevesser. He kind of created this definition, and then when it arrived in Kampala, it got accepted without any changes. After 2 weeks of states like the United States trying to reopen it for negotiation, no, it was adopted. The big
one guy was the fellow who came up with the formulation that everybody else finally accepted.
It wasn't that he defined it. He ran the process. He was the diplomat that set up the process where all of the other states sent delegations and negotiated all the details, all of the technical details.
And you were there watching it all happen.
Yeah.
The debate took place. Is there anything you can say about the stages of argumentation that developed over time as they sorted out what they got closer to the definition they finally wanted to accept?
Yes. The most fascinating thing of all was, well, there's a few fascinating things. One of them was that in this seemingly intractable discussion that had deadlocked the great powers during the Cold War, the method that the diplomats used to come to a definition was, instead of coming to great big principles about what aggression entails, they went to a much lower level of generality. They went much more specific, and they traded language. They based the definition on past precedents, and they would do little trades of language here and there, little technical modifications. And in this way, questions that were controversial or unresolved, placed in square brackets in the definition, one state would trade one for the other. And over time, all of the debates were resolved in this way, in a grand compromise. So also the process wasn't a belligerent process. It was kind of done in a relaxed atmosphere in Princeton for long periods of time, outside of the New York venues that usually provoked competition. And diplomats were asked to participate in their personal capacity, not representing their states. Their names weren't taken down in the final reports. Countries didn't present position papers. There was coordinators who put together all the different statements of every diplomat and then fed it back to the diplomats at the end of each session of negotiations. All of these innovations that Christian Venevesser, the president, the guy that ran the working group, implemented, made for the solution of all of these intractable problems, the resolution of them. So it was really a real masterclass in diplomacy to watch this thing happen.
Mm-hmm. Fascinating, yeah. And now you mentioned originally that the tension was between the notion of involving the intent of the aggressor, presumed aggressor, versus just who fired the first shot kind of thing.
Mm-hmm.
In what way was that issue resolved? You say that it combined them in the end.
Mm-hmm.
How do you bring the intent? How does the current definition include questions about intent?
The current definition is a blanket prohibition on the use of force. So there's no it used to be before World War I, states could wage war as they please. There was no prohibition on force. This here is the reverse. This is a blanket prohibition on force, which is based on the UN Charter, which contains a blanket prohibition on force, meaning whoever strikes first is the aggressor, except under two circumstances. One, if the United Nations Security Council authorizes the use of force under Chapter 7. Two, if a state has sustained an armed attack. If an armed attack has occurred, the UN Charter says.
But then that's not the first shot. That's
Mm-hmm.
the shooting back.
So if you've been attacked and you respond, it's self-defense. It's not aggression. There's no allowance for preventive strikes.
I see.
Yeah.
Right. So you're theoretically, all right. So it's not just a question of who shoots first.
There's self-defense is allowed, and there is a potential carve-out for uses of force that fall below a de minimis range. So uses of force that are not manifest violations of the UN Charter, that's how it's defined in the crime of aggression definition. If it's not a manifest violation of the UN Charter, it cannot be an act of aggression attracting leadership responsibility. So, for example,
let's say if I am the aggressor and I shoot first, but I'm using blanks
right,
instead of real bullets, or I'm shooting maybe over their heads and clearly not trying to kill anybody.
Mm-hmm.
What else? What are some of the other exceptions that might, or is it because I'm trying to scare you away,
right? Because
you're about to do harm to somebody that I care about,
right? Okay.
Now, those would be all exemptions from my being prosecuted as an aggressor.
Correct. So a few shots fired across a border are not going to amount to a manifest violation of the UN Charter. So there's a big carve-out there. The question is whether a few drones, US drones flying around in Pakistan, if they haven't been authorized by Pakistan, that might fall below a de minimis threshold, or the court might find that it amounts to a manifest violation of the United Nations Charter. But there's a lot of jurisprudence that discusses this question. So there's cases and other sources will guide the judges. Another question is whether a humanitarian intervention, so a use of force that's the first use of force by, for example, NATO intervening in Kosovo to prevent a massacre of Kosovar Albanians by Slobodan Milosevic without Security Council authorization, without self-defense, whether that amounts to an act of aggression. And this was one of the great debates in the working group on the crime of aggression. And what they said was that if an act by its character, gravity, and scale amounts to a manifest violation of the UN Charter, then it's aggression. So the court will have to determine whether that humanitarian act by its character amounts to an act of aggression, whether humanitarian rescue is a violation. But these are gray areas that we're discussing now. Mm-hmm. Most uses of force are going to be of the variety that, Turkey invades Syria, like what just happened, without any kind of authorization for the use of force, without a good self-defense argument, completely disproportionate use of force, even if there were Kurdish bullets flying over the border into Turkey from Syria. Self-defense needs to be necessary and proportionate, and that wasn't for sure.
So in a real court, a real case where somebody's charged, or this is the kind of argumentation that would go on, was
correct,
whether it met a certain level of seriousness, etc.
Yeah.
And what the motivation was, whether they were protecting, etc. Okay, that sounds reasonable. Okay, and so everybody now pretty much can accept this. If the U.S. weren't so intent on, and Russia and these other countries were not so intent on saving their own hides from potential charges of aggression, would most people everywhere acknowledge this definition and be, in principle, right. Are most people on board, or are there still holdouts on abstract concerns?
Every state, including Russia, the United States, Israel, has accepted the UN Charter prohibition on force, meaning the blanket prohibition with two exceptions: self-defense and Chapter 7 authorization for peace enforcement. Every state agrees to that. The only disagreement where these states do not agree is that individuals should be held accountable for it. So the United States and Russia have not agreed, and nor Israel, that their own leaders should be held accountable for these violations. As the system existed after World War II, and until today, until 2010, states would sue other states at the International Court of Justice, or they would condemn other states at the United Nations General Assembly. There was no court that was going to judge an individual for waging an illegal war. That's what's changed now.
Mm-hmm. Well, it strikes me as very great progress. You should feel proud of yourself.
Thank you very much. I was mostly an observer, but it's nice of you to say so.
Yeah, that's beautiful. Now, the only problem is, how do you enforce a thing like that?
Right.
Oh, one small detail there. How in the hell are you going to make it work?
Right. So
and
now,
obviously, that's the biggie. What's the best thinking on that now?
I have a chapter in the book, which is maybe the most exciting chapter, called Your Turn, Mr. President, or You're Under Arrest, Mr. President, I forget. And it gives a bunch of arrest scenarios that have happened in the past, and it comes up with the theory of arrest. So arrest scenarios where the UN peacekeepers have arrested, like where a successor regime has arrested a perpetrator. For example, President Gbagbo was arrested with the assistance of French peacekeepers who went into his compound. There was Ukrainian piloted gunships, big helicopters, ground troops, and he was just overwhelmed and arrested. Or Jean-Pierre Bemba, the vice president of the Congo, one of the richest men in Africa, was arrested in Belgium when he went to travel to Belgium, and police came up with a pretext to enter his house, and he was apprehended there with his bodyguards outside of the room. There's been arrest by private contractors who have captured Yugoslav perpetrators of war crimes and then transported them to international tribunals for trial. The most successful manhunt in history was orchestrated by the International Criminal Tribunal for Yugoslavia, a UN Security Council court in The Hague. 163 indictees, every single one of them either arrested, captured, or killed. So people say that the international system is not effective, but the Rwanda Tribunal, the International Criminal Tribunal for Rwanda, had similar success. Domestic systems capture and try perpetrators as well, even in Canada. So there's been successful arrest, and the book suggests how an arrest for the crime of aggression could potentially take place.
Mm-hmm.
Yeah.
I can just imagine somebody marching into the White House and saying, "Mr. President, come with us."
Right.
And put your hands behind you or put the handcuffs on you.
Right. I mean, the way that arrests take place, two factors need to be in place. The person has to be politically marginalized, so that takes time and effort, and or geographically marginalized.
It's been great fun. I really appreciate this, and I hope we can continue our conversation another.
I really enjoyed it, and I hope we can have dinner in Toronto one of these days.
Excellent. Very good. And anytime you're coming this way, let me know.
This conversation is one of the weekly series Talk About Saving the World, produced by Peace Magazine and Project Save the World. Please visit our website at tosavetheworld.ca, where you can sign the Platform for Survival, a list of 25 public policy proposals that, if enacted, would greatly reduce the risk of 6 global threats to humankind. Come back next week for another discussion of a serious global issue.